Revocable living trusts are very commonly recommended in different states or by financial advisors because it avoids probate on somebody's death. And if probate's not going to have any benefit, why go through a probate? Totally reasonable. So with a revocable living trust, the person who creates it is called the trustor or the grantor. They typically appoint themselves as a trustee, the person managing it. They're typically the beneficiary of the trust. And the trust says, on my death, all my assets go, to my spouse or whatever. And it avoids probate. So totally makes sense. Problem is, beyond typical problems with a trust and that they're not necessarily funded like they should be or administered like they should be. I'm not going to get into that. But the key problem that I want to point out to you with a revocable living trust in the state of Washington is that if you say in your trust, on my death, all my assets are going to go to my spouse in this supplemental needs trust, my revocable living trust creates for my spouse, state will not honor it because the state will say, if you want to protect assets when you're gone for your spouse against long-term care costs, such that those assets don't count for Medicaid eligibility, you have to do it through a will. This really surprises a lot of people. Estate planners who don't do Medicaid, obviously financial advisors or others who are giving good estate planning advice without paying attention to its bad advice because it doesn't consider Washington's law and Medicaid's eligibility rules. So if you got advice that you should have a revocable living trust, okay, see an elder law attorney because whomever you talk to may not realize that they gave you bad advice because in other states or in other situations, a revocable living trust might have been a good idea. Certainly at ELG Estate Planning, we do revocable living trusts in the appropriate situation for our clients, but often it's not appropriate. And then we advise the client that a better plan is a will with a supplemental needs trust. Let me show you why. The best way, I think, is to give an example. So let's take a couple, Fred and Betty. They've got a house. It's worth a modest house. It's worth $300,000. They've got retirement, savings, investments, countable assets, and their estate is $1 million. So what happens when the first spouse dies? Let's have Fred pass away first. When Fred dies, Washington is a community property jurisdiction, 1/2 of the million or 500,000 is not going to go outright to Betty. Instead, it's going to go to an asset protection trust, creating this nest egg for Betty. Why is that important? Everything in that asset protection supplemental needs trust created by Fred's will for Betty's benefit is non-countable by Medicaid. So what that means is that 500,000 is there. It's protected. It's for Betty. She's the beneficiary. She can't be the trustee. Somebody else will be the trustee. Usually it's a trusted family member, but it could be a professional. But the point of it is that Medicaid's never going to count that $500,000 against Betty when she needs Medicaid to pay for her long-term care. Having a will with an asset protection trust ensures that that surviving spouse will not become impoverished due to long-term care costs. Is it worth the cost of a probate to protect half the assets, to protect $500,000? That really is more rhetorical because obviously it is. There's also the possibility of protecting more than half the assets. So sometimes we know that one of the spouses is going to be passing. And so in this case, same set of facts. Fred's is sick. He's likely to pass. So we know, for example, that Betty really is going to need long-term care. Fred's been taking care of Betty at home. Betty has dementia. through their estate planning documents that were prepared before Betty's dementia took over, causing her to lose capacity, they prepared certain documents that allowed her to give all of her assets over to her husband, such that when he died, 100% of the couple's assets, $1 million, is going to fund this trust for Betty. $1 million, all their assets, none of it accounts against her when she applies for Medicaid. You might say that makes no sense. This is Washington, it's community property jurisdiction. Recall when we were talking about the financial durable power of attorney needing to have authority to revoke community property agreements, to do separate property agreements, also to transfer the assets from one spouse to another. That's how we get the opportunity for 100% asset protection. And why that is so important is that the assets, all the couple's assets have been preserved and protected. So when Betty needs to go into a care facility, maybe it does have a private pay period. Okay, she's got $1 million to privately pay, but when that facility will accept Medicaid, she'll be financially eligible. Even if she has $1 million in the trust, or maybe 900 left, or 800, whatever the case may be, she is eligible. This is how we get asset protection for a surviving spouse. Keep in mind what that means is that a spouse has died.